Welcome, everybody, to Access to Justice Week. This is the panel entitled Sentencing Circles, Gladue Reports, and IRCA Reports. I'm pleased that we have so many registrants today, and we have a wonderful panel for you. So I think what I'd like to do is begin with the treaty land and water acknowledgement. And then following that, I'm going to do a introduction of our panelists. And then we're going to move into a question and answer session where I'll present some questions to each of the panelists and give them an opportunity to speak for about 10 minutes. And then following that, there'll be some time for Q&A. And I would ask that if you do have questions, you'll see on the bottom of your screen, there's a Q&A icon. Please use that to put your questions in, and we'll get to them at the end. So now I'm just going to read the land acknowledgement. Between 1871 and 1906, treaty commissioners acting on behalf of the Crown signed 7 treaties with First Nation leaders in what is now called Manitoba. This land is the homeland of the Métis Nation and the traditional territory of the Cree, Dakota, Dene, Anishinaabe, Oji-Cree, and Ojibwe nations, all of whom have and had a spiritual relationship with this land since time immemorial before the signing of the treaties. The MBA represents approximately 1,600 and diverse members throughout our province. Our membership includes students, faculty members, lawyers, and judges from a variety of backgrounds who gather in lands and territories, sharing the rights and obligations of these 7 treaties. We are pleased to welcome participants from the different territories across Canada. We ask each of you to consider the lands and territories on which you practice as we acknowledge with respect and gratitude the many First Nations, Métis, and Inuit whose footsteps have marked this land for centuries. We hope each of you will take concrete steps to gain an understanding of the customary laws of Indigenous peoples in relation to these sacred lands they have lived on since the beginning of the time. We also wish to acknowledge that the water we enjoy in Winnipeg comes from Shoal Lake, the lands of the Shoal Lake 40 First Nation in Treaty 3 territory. So I should introduce myself. My name is Wendy Martin White, and I am a lawyer that practices mostly criminal defense work in Winnipeg and throughout the province. I am very pleased about this session as it's something that I get to practice day in and day out. And for some of the things that we're going to talk about today, sentencing circles in particular, I'm looking forward to participating in one someday. So I'll begin by introducing our panelists. And there is a I'm not sure if you can all see it. I think you can. There is a link that's in the webinar chat that will also give you more information in November about the recording that's taking place right now. So if you would like to reference it, you can go there. So I'm going to try to shorten the bios, but if you want more information about the panelists, it's on that same link. So the first panelist I'm going to introduce is the Honorable Associate Chief Judge Leanne Martin. She obtained a Bachelor of Arts degree from the University of Winnipeg before studying in France at the University of Paris to Assas. After earning her degree in civil law, she remained in France until 1996, practicing in the areas of labor law and corporate commercial law. Upon her return to Winnipeg, she earned her common law degree from the University of Manitoba, then practiced at the firm Aikens, Macaulay, and Thorvaldson. She also served on numerous administrative tribunals and taught a comparative law course at the University of Manitoba. She was appointed to the Provincial Court in 2007 and named Associate Chief Judge of the Provincial Court in 2022. She primarily presides over criminal and youth law matters. She regularly sits in First Nations communities, including spending 6 years in St. Teresa's Point. Associate Chief Judge Martin has remained active in numerous committees and organizations, including the Canadian Institute for the Administration of Justice and the National Judicial Institute. She is a former president of the Manitoba Provincial Judges Association and the Canadian Association of Provincial Court Judges. She remains committed to continuing education and is regularly invited to give lectures and presentations in various forums. The Honorable Judge Jerry Lee Ryle. Judge Jerry Lee Ryle is Anishinaabe from Lake St. Martin First Nation. She graduated from the University of Manitoba in 2005 and received her call to the bar in 2006. She practiced primarily as a Crown attorney with Manitoba Prosecution Service until her appointment to the Provincial Court of Manitoba in May 2025. Melissa Brown, Justice Programs Manager for MKO. I'm going to attempt to give her Anishinaabe name, the Anishinaabe community she's from. Sigasik Pitsi Odotem is Anishinaabe from the community of Manitoba Bar located in Treaty 3 territory. Shigashik is a pipekeeper, sun dancer, and member of the Medibaway Lodge. Melissa pursued her formal education at the Red River Community College and the University of Winnipeg, majoring in community development, community economic development, and urban and inner city studies. This led Melissa to careers in child and family services and justice. She has extensive knowledge regarding social issues that impact First Nations peoples and communities. Her passion for equality is grounded in her own and her family's personal experiences, and she strives for meaningful action in the name of reconciliation. Melissa is firm in her ways of knowing and being Anishinaabe. Melissa's had the opportunity to learn alongside elders, knowledge keepers, and grandmothers. She credits Great Spirit and the natural beings as her teachers in classrooms. She is committed to ensuring Anishinaabe teachings continue through engagement, sharing, and ceremony. These teachings belong to all of us. No one person owns these teachings. Creator loves us all. Dr. Patrina Duhaney, Assistant Professor, Faculty of Social Work, University of Calgary, and founder of Nashura Consulting, Inc. Dr. Patrina Duhaney is the founder and CEO of Nashura Consulting, Inc., and an associate professor in the Faculty of Social Work at the University of Calgary. With over 20 years of frontline research and leadership experience, she is a nationally recognized expert on race, gender, and justice, whose work bridges academia, community practice, and the legal system. Through her consulting group, she serves as the lead assessor conducting impact of race and culture assessments, which will typically be called IRCAs as we go forward. She does this for individuals involved in the criminal justice system. Her work applies critical race theory, anti-Black racism, and trauma and violence-informed frameworks to examine how systemic racism, trauma, and social inequities shape people's experiences within and across systems. In addition to her assessment work, she provides counseling and mediation services to individuals, couples, and families, and offers consultation and professional training to lawyers, mental health practitioners, and justice personnel on equity-informed and trauma and violence-aware practice and decision-making. Zilla Jones, lawyer, Jones Law Office. Ms. Jones is an African Caribbean Canadian woman living and working on Treaty 1 territory the home of the Métis Nation in Winnipeg. She has an honors degree in music, vocal performance, and graduated from Robson Hall Faculty of Law in 2011, where she won numerous academic awards. She articled at the Public Interest Law Center of Legal Aid and is now a sole practitioner with Jones Law Office, where she practices criminal, refugee, and child protection law and has appeared at every level of court in Manitoba and the Supreme Court of Canada. She is also currently a sessional instructor in the Faculty of Law. As an anti-racist educator, Zilla has given presentations to the University of Manitoba, Red River College, Islamic Social Service Agency of Manitoba, Manitoba Teacher Society, Commonwealth Bar Association, and others. She's also a published writer and has won first place in 4 national and international competitions, is published in 5 national magazines, and has secured a literary agent for her first novel. She is a board member of the John Howard Society of Manitoba and the John Howard Society of Canada. So there you have it. We have an extremely accomplished panel for you, and I'm very excited about our presentation for you today. I'm going to draw on each of our panelists, and I'm going to start with Judge Ryle. I had sent our panelists questions in advance of today, and so they've had some time to reflect on the questions. So I'm going to pose the questions, and then each panelist will come on and speak for about 10 minutes. So Judge Ryle, I had asked, what are Gladue Reports and sentencing circles, and what purpose do they serve in the criminal justice system? What role do they play in assisting a judge in arriving at a just decision? And what role can they have for the offender, victim, and community?
All right, good afternoon, everyone. It's a pleasure to be here today speaking about 2 very important topics. So given the time constraints, I will be speaking very generally about Gladue Reports as well as sentencing circles. Put simply, a Gladue Report is a sentencing report that addresses Section 718(2)E of the Criminal Code. That section tells us that when imposing a sentence, courts must consider all available sanctions other than imprisonment that are reasonable in the circumstances and consistent with the harm done to the victims or the community, and should be considered for all offenders with particular attention to the circumstances of Indigenous offenders. The code uses the term Aboriginal, but the more appropriate term is Indigenous, which I'll be using throughout. And Indigenous includes First Nations, Métis, and Inuit peoples. These reports provide insight into how colonization has impacted the life of an Indigenous person who has pleaded guilty or been found guilty of an offense. Section 718(2)E was added to the code in 1996 to address the overrepresentation of Indigenous peoples in our criminal justice system, particularly in jails. The Supreme Court of Canada's Gladue decision in 1999 and later Aiello in 2012 gave us further guidance with respect to the use of these reports. So during this time, when we think about the 1990s as well as the early 2000s, counsel and judges were struggling with how to apply this section. When we think about what we collectively understood about the legacy and impact of colonization during this time, that struggle certainly makes sense. We have come a long way thanks to the Truth and Reconciliation Commission and other efforts, but there still is more work to be done. Now, what does a Gladue analysis involve? The court must consider 2 sets of unique circumstances: the systemic or background factors that may have contributed to the person's involvement in the criminal justice system, and the types of sentencing procedures and sanctions that may be appropriate because of their heritage or connection to the community. Here in Manitoba, we typically see a combination of a pre-sentence report with a Gladue component. These are usually prepared by probation services and cover a wide range of topics, including criminal history, family background, education, employment, substance use, peer relationship, recreation, and the impact on the victim. For Indigenous individuals, the report also explores their connection to culture, spirituality, and their community. The writer of the report interviews not just the individual, but also their family and community supports. It's important to note that each province handles these reports differently. Some separate them from PSRs, so there's a standalone Gladue report, and others only order them if jail is a possibility. Saskatchewan, for instance, even piloted their own use in bail applications. In Manitoba, the ordering of PSR Gladue report is not contingent on jail being a possible sentence. Anyone that identifies as First Nations, Métis, or Inuit is entitled to request the preparation of the report. There's also been some discussion nationally about moving away from the term Gladue, since Jamie Gladue herself did not benefit from one when her case went through the criminal justice system. And alternatives such as 718.2E report or impact of colonization reports have been suggested as alternate terminology. Now let's talk about sentencing circles. Sentencing circles are a restorative justice approach. They bring together the person who committed the offense, those harmed, as well as the community. The goal is to restore balance, promote healing, and hold the person accountable. The circle format is rooted in many Indigenous worldviews. Everyone sits together, there's no hierarchy or barriers, and it's about equality, healing, and shared responsibility. When a judge is involved in a sentencing circle, the process still includes aspects of the conventional sentencing procedure, such as Crown and defense submissions, and the ultimate authority for sentence resting with the judge. But the circle expands participation beyond the usual courtroom roles. It becomes, in essence, a living and breathing Gladue report, drawing on the same people and the same information that would be presented in the Gladue report. So in terms of what purpose these tools serve in the criminal justice system, they can help the court arrive at a fit and appropriate sentence, and it also complements or can complement the roles of counsel in the process. They may give deeper insight into the offender's background and potentially offending behavior. They may address public interest in a more meaningful and in-depth manner when hearing directly from the community. For the criminally involved person, colonization may have impacted them and affected them so deeply that they can't articulate its impact on them, their family, or their community. The report writer can help tell that background. Additionally, the circle allows the person to sit with the harm they've caused, promoting accountability and healing. It can also connect them with resources that may reduce their chance of reoffending. For victims, being heard is powerful. The victim impact statement is already an avenue in the criminal code that permits them to speak about the impacts of the harm caused. In a circle, they may get a better understanding of why they were harmed and may also have community supports and resources identified, all of which can promote feeling heard, understood, and supported, which fosters their own healing and restoration. And for the community, these processes can foster accountability and public safety. They ask, how can we help this person not do this again? What supports are needed for all of those involved? Ultimately, the court takes into account the circumstances of the offender, the impact on the victim, and the public interest when arriving at a just sentence. And these tools are important pathways in achieving justice that truly reflects the circumstances of all those involved. All right, Ms. Martin-White.
Thank you. We're now going to move to Melissa Brown, and the questions that I had posed for her were, tell us about MKO, its justice program, and the role you and your organization play in writing Gladue reports and in assisting with sentencing circles. What are some of the protocols that your organization has before participating in a sentencing circle?
Thank you. Good afternoon, everyone. Sagazagain Dishnikas, Bashutotam, Manitoba and Doji, Winnipeg Nongum, Dijita, Bushugichi Manitou, Miigwichka Kanag, Ego, Ishigiwan, Nongum, Miigwichka Ijibiwug, Miigwichka Izi, Gizigog, Miigwichka Izi, Bimawazan. Just introducing myself first and foremost, and just a quick shout out to Creator, thanking him for today, for everyone here joining virtually, and thanking Creator for the day. First and foremost, thank you for the invite to come and spend some time with you today. As Wendy introduced, my name is Melissa Brown, and I'm the Justice Program Manager over at Manitoba Kiwaitanawi Okimakanak, which I will refer now to as MKO. Prior to my time over here, I spent some time with Manitoba Justice in our Community Service Division and at our Restorative Justice branch. So a little bit about MKO is MKO was incorporated in 1981 as a nonprofit political advocacy organization that aims to provide a collective voice on various issues of inherent treaty rights, Aboriginal and human rights for the citizens of the 26 nations that we govern and provide support to and that we represent. So our MKO nations are located on the signatory treaties of 4, 5, 6, and 10. As we continue to grow and evolve, MKO continues to explore ways to strengthen and promote the interest of First Nations by achieving self-sufficiency, with respects to all areas that affects the lives of Northern First Nations communities and citizens. Now I'm going to jump into the Justice Program. So the MKO Justice Program was created in response to the 1991 report of the Aboriginal Justice Inquiry here in Manitoba. It was MKO's primary step towards the creation and implementation of a First Nation justice system program as recommended by the commissioners of the AGI. Move forward to present day. What started out as four individuals who were located in the Thompson office has now grown to present day. So our current First Nation Justice Strategy program consists of our Community Justice Worker Program, which we have vacancies throughout the North and in First Nation communities, also in our sub-office down here in Winnipeg, and then our home office in Thompson. So along with our justice workers, we have our Indigenous court worker program, again, throughout the North. And then we also are home to the First Nation Justice Navigator Hub program with navigators, one down here in Winnipeg and one in the North. Excuse me. And then also just new to our program is the post-sentence support program that is stationed, home offices in Nelson House Cree Nation, but do a lot of traveling throughout Manitoba, attending institutions and meeting with clients and various committees in towns and cities. So currently, MKO does not have an active Gladue program or any writers. However, we are in active discussions with the federal and provincial government in response to the MKO Gladue Pathways to Healing initiative. What's unique to this initiative is we all know what comes with a Gladue, normally conducted by a probation officer. They, meet with the individual, with the collaterals. Sometimes those members may be from the First Nation community itself. However, there is not a lot of support that goes into post report, and there needs to be. We are interviewing people, we are interviewing families, collaterals, leadership who, for the very first time when they meet a writer, they're opening up and sharing a lot. And for some people, this could be the first time they're talking about very sensitive matters that they have done a lot of work to work through such events they have encountered throughout their life. And for a lot of First Nations people, we recognize that as, trauma, and that's a result, again, into a result of colonization. And so we really came together and we're like, how do we make this really responsive to the individual, the needs of the individual, the family, and the community? And so through this initiative, we want to introduce, and our goal is creating a healing and wellness plan through a trauma-informed lens. So the plan will work with First Nation people who are involved with the justice system by assisting them to share their story, tell their story, and while sharing that story, ensuring that those appropriate supports are there for the individual. So again, access to could be medicines, access to an elder, or if they do not choose that traditional route, then access to a social worker or a medical team. Who knows? It's based on the individual's needs. So allowing them to share their story, but also pinning why and how they became in conflict with the law, and the criminal and involved in the criminal justice system, because that's really important when we're writing these reports. So the wellness plan will consist of interventions and supports that are going to be designed through a restorative response, but also a community response, and ensuring, if again they choose that culturally responsive approach. Um, Giving that option to an individual is really important. Do you want to walk the road of the traditional route, or do you want to do a little bit of a hybrid, or do you choose to walk this path? Is really important to give that option to the individual. So providing those supports, and while we're supporting those approaches, we also want to target in on the identified needs of the individual, not the risks, the needs of the individual. Also their kinship, so their family, looking at the needs of their kinship as well, and the community, and then bringing those all those needs together, and then formulating an official wellness and healing plan for that individual. During this whole process, this is also going to provide an opportunity for the person who is involved to take responsibility and for their actions and begin making those repairing that harm that they have caused. And this also allows them to begin that therapeutic path that we hope this encourages for them to walk forward. We can refer to as their healing plan. So the healing and wellness plans will be formally prepared and submitted by a trained Gladue writer. And these will also be used hopefully for judicial consideration as a responsible and meaningful option. And again, taking into account that input is going to come from their family, kinship, and the community as well. Because again, we want to be able to support post sentence, post report. Really, really, really important. And this is also just increases the options, which are meaningful, responsive, and culturally responsive, and again for judicial consideration, but also well, in hopes that it will take into consideration the sentencing of First Nation offenders. So hoping, fingers crossed, tobacco down, that happens. Circles. Circles is something I am very, very, very passionate about, and my knowledge, and there's no way that I'm able to talk about circles without looking at a circle through a traditional lens. The very first time I was offered to facilitate a sentencing circle right off the bat when I heard sentencing, and I did provide recommendations, and that was during when I was in my PO position. But even that term sentencing circle, it just did not sit well. We want to be responsive when even with our terminology, when we are working with First Nation clientele, and just even the switch of one word will make a difference. So from a very young age, I was taught and learned that the space and the content inside a circle are sacred. And in every circle, there is going to be the presence of a spirit, and there's going to be intent. And so that is how, when we're talking about circles, it is the worldview that I hold. I'm also, again, able to walk in both worlds, though, walking that traditional path and incorporating that into the circle. However, based on the request, I'm also able to remove that traditional protocols within the circle, but still seeking the guidance of leading of facilitating the circle. Because everything we do as Anishinaabe people, we're always offering our tobacco, our say mot for the guidance while we're conducting something. And so every time I have led a circle, I'm always offering that tobacco, and so I can have guidance. And again, it doesn't matter if it's a traditionally led one or a non-traditionally led circle, but still, that as the facilitator or the conductor, I have to ensure that I am still able to have the presence and the guidance of spirit. So it's really important to incorporate that. And again, Anishinaabe worldview is everything is circular, everything in the circle. As it is in life, we are all interconnected. All life is cyclical. Um, One thing that I learned through my adoption of the Oglalalakota, my relatives down in the south, is when people in our circle, again, same as Anishinaabe, we're sacred. But this sacred space, what I've learned through our relatives as well, is it's a space for talking. It's a place for ceremony, for prayer. And when people are all in that circle, we're committed to helping one another. And so when we're also helping, that means we're taking on the responsibility as well for each other's healing. So it's really fitting when we're conducting these circles for sentencing, forgetting, letting go, whatever circle it might be. It's really important that we pay respect to the foundation of those circles. Um, we have we have had lots of requests come in to lead judicial sentencing circles within the community, within communities. However, again, I really do my best to change that terminology into healing circles, because really that is what's happening, and that is the intent of one of the foundational pillars of a circle. So we have conducted some circles here in partnership with the judicial. One of them would be of a young man out in Chimawawin First Nation, and it was absolutely amazing. We were able to incorporate the ceremony into it, and then also it was such a beautiful hybrid where we had judicial, we had the complete setup of a circle, and we followed our protocols. So again, first and foremost is our tobacco was offered, but also, ensuring the goals of the healing circle were met. So we did see the healing process between the young fella and the community, because that's who was the victims of the harm he had caused. So we seen that. We were able to promote that understanding of each other. There was some rebuilding of trust and also respect for each person that was present. Um, did it solve the issue completely? No, it didn't, because again, there's more work that has to be done into post, right? So it didn't solve all issues. We were able to share experiences, our position of the event and whatnot, and we all learned from each other. Not only, people from the community, the judicial members of the judicial had learned, I had learned, and I think the young man had learned as well. And I know for a fact participants learned, because they were coming up afterwards and asking questions about this format of court happening in this way. And then again, we were also able to, while listening, identify, personal and community issues, which again, as part of that circle, we all have that responsibility to engage, and we're all responsible for something. I will end with, when we're in a circle, there is no beginning, there is no ending, there is no hierarchy. And again, I do have to reflect back to it because it was so beautiful on so many levels, to this sentencing circle in Chimawawan. Is we seen the presiding judge really listen, really participate, and really become part of that circle. And that was beautiful because that truly represents, when I say there was no hierarchy, there was none. We all carry different responsibilities when we're in that circle. But again, there's no hierarchy when we're looking at a circle through a First Nation lens that is really built on First Nation foundation. And again, these are all teachings that have been passed on to us from, our ancestors who have conducted this type of justice for forever and ever. I'll stop there. Miigwech.
Thank you so much, Melissa. I can say, and it will probably be a question that I pose to you, because I was just up in Shamattawa yesterday, which is why I'm exhausted today, for a sentencing where we had hoped that we could enlist your services. And I'll pose my question later because I can so much see the value if we had had you and your organization, but I'll pose it later. I'm now going to move, and I'm seeing some questions come in that are just wonderful, so we'll have some good Q&A. All right, I am now going to move to our next panelist, who is Judge Harvey. Sorry, God, my apologies to Judge Martin. When you were the circuit judge in St. Teresa's Point, you were involved in a sentencing circle. Tell us about that experience. Where are some of the challenges with increasing the use of sentencing circles within the justice system?
Okay, first of all, I just wanted to thank everyone for participating today. We have a significant number of participants, and that just, I think, goes to show how important these conversations are. And talking about the sentencing circle, I wanted to paint a little bit of a picture just to try to convey the process itself and what transpired that day. So I was a circuit judge up in St. Teresa Point for 6 years, and tried to engage the community more, and tried to look at sentencing in a different way. At one point, the Crown and defense lawyer approached me and asked if I'd be prepared to do a sentencing circle in Wasagamak, a community in the Island Lake area, but which we don't normally sit. So I welcomed the request, and then began the process of setting up what was a sentencing circle, but actually, just reflecting Melissa's words, was much more of what I would call a healing circle. In this case, the healing circle dealt with a man who had unintentionally shot and killed his friend while they were on a trap line hunting moose. Because they were friends, the families were also deeply connected, and two very prominent families within the community, one that was a cultural family and one that was a Catholic family. Our community justice worker from Wasagamak, who is sadly passed, was an elder and also a knowledge keeper in Wasagamak. And he was the one who was behind assisting with the healing circle. So the day started, we flew into St. Teresa Point. We took the boat over to Wasagamat. We met with Chief and Council, and we then went to the school where the Healing Circle was to take place. Unbeknownst to me as the judge, the elder had been working with both sides of the families for a year before this day. He had taken the victim's family to the island where their loved one had passed. There was a lot of discussions and time that was needed to get them to a place where they felt that they could actually uh, be able to speak about their feelings, their grief, and what had happened to them. The way that the day started was with ceremony. There was drumming, and there was also smudging. The community came, the families also came. As we were saying, that the way we were set up was probably more in a conventional type of way. I was kind of at one end of the circle. We had the lawyers on each side. The offender was sitting in the middle of the circle, and everybody else was around. So we started that off with kind of what had happened that particular day. And then what happened after was something that we're usually very uncomfortable with in the justice system. We had a microphone, and we passed the microphone around to anyone who wanted to share their grief, share their thoughts, ask any questions. And that in and of itself was a very, very interesting process, because it's not something that we often do in the justice system. It's just allow people to address each other freely within the system. One of the things that I learned that day is not only was there grief that had been experienced by the victim's family, but there was also grief that was experienced by the offender's family. Because the offender had killed his best friend, he himself was grieving the loss of his friend, and had moved away from his wife and his children, and they were grieving the husband and the father that they had had previous to the incident. What happened then, when everybody began to talk, was an experience of tension, anger, but also some forgiveness. During the whole process, the offender sat in the middle with the head down, oftentimes crying. At one point, defense counsel became worried for his client, and wanted me to caution people in the words that they were sharing. I advised counsel that we needed to allow people to speak, and the process continued for quite some time. After everyone had felt that they had said what they needed to say, sentence was passed. And what happened after was one of an event that I will never forget. The victim's widow walked over to the offender and hugged the offender. Then everyone started coming forward and hugging one another. Both families began hugging one another. People came up and hugged me, and there were more tears, and a sense of relief and of understanding that hadn't existed before. When I reflect back on that process, as Melissa was saying, it is a very emotional process. I think it's one that is one that brings into really into play in an acute manner is accountability of the offender to those that they've harmed and the community. And it allows for true healing that we often don't see in our colonial process. People are allowed to freely express themselves and feel that they're, I think, are being heard. Um, so these are amazing, amazing opportunities, I think, to look at how we are doing justice and what justice actually means to our society and the people that we serve. There are challenges, however, to doing sentencing circles. So one of them is the time. Our system, when you look at our system, it's already very slowly moving. And as I indicated in this particular case, it took about a year before everybody was ready to come and speak about their feelings. The expense, it was an entire day. We needed a plane to come in plus the boat. So it makes it more challenging in a system that's already very resource strapped to be able to do this for the on a 100% basis. But looking at that, I would also like to point out that not all healing circles need to be as involved or require that type of healing to take place. Um, there's different healing that can take place. And I think that we can also adapt to the situation before us, the needs, as Melissa was saying, the needs of that individual and the harm to the community or to individual people. So perhaps we can start looking at these in a different and a more open manner instead of looking at them as a monumental task to undertake. Because as I said at the beginning, I think we do need to ask ourselves as a society, what is it that we really want from our justice system? And how can we achieve that? I really think that sentencing circles or healing circles is certainly a good place to start. Thank you.
Thank you, Judge Martin. I know some more questions coming in that I'll be directing your way. And now we'll move to IRCAs and Patrina Duhaney. The questions I'd posed to you were, what are IRCA reports? What purpose do they play in the sentencing process? Tell us about how you approach writing an IRCA report and what have been some of the challenges in having IRCA reports accepted within the jurisdictions that you've submitted reports.
Awesome, thank you. Good afternoon, everyone. It's wonderful to see so many people here today, and to also know that we have such a diverse perspectives represented on this panel and among our participants. As Wendy said, my name is Dr. Patrina Duhaney, and I was one of the first assessors who completed the first Impact of Race and Culture Assessment, also known as IRCA, in Manitoba. And since then, I've had the privilege of conducting these assessments across Canada, working with courts, lawyers, and communities to raise awareness of how systemic racism and social inequities shape people's experiences in the criminal justice system. And so over time, this work has offered me a deeper understanding of both the promise and challenges of integrating IRCAs into sentencing processes, and how this knowledge can also help move us closer to genuine access to justice. And so, what are IRCAs and why were they developed? IRCAs were introduced to help address the overrepresentation of Black and racialized individuals in the criminal justice system. They emerged in response to judicial recognition that systemic racism and discrimination shape the lives and circumstances of many Black and racialized individuals who appear before the courts. And so IRCAs have gained prominence after R versus Morris 2021, where the Ontario Court of Appeal affirmed that sentencing judges must consider the impact of race and systemic factors when sentencing Black individuals accused of a crime in Canada. And so the government has invested money towards these IRCAs. And so I hope that investment stays intact. And so IRCAs were therefore developed to provide that contextual evidence-based insight into how racism, poverty, migration, trauma, and other social inequities influence a person's life trajectory. And they help courts move beyond stereotypes and individual blame and to understand how structural inequities shape opportunities as well as outcomes. And they are not about excusing behavior, but about explaining context, helping the court to see the whole person, including the barriers they have faced, the resilience they have shown, and their potential for rehabilitation and reintegration. And so when we look at the purpose of IRCAs in the sentencing process, one of the things I want to highlight is that within sentencing, IRCAs play a critical role in promoting fairness and equity. They provide the court, again, with that fuller picture of how systemic and structural factors, such as anti-Black racism, racial profiling, poverty, housing insecurity, or educational exclusion may have contributed to an individual's involvement in the criminal justice system. And so IRCAs encourage more informed and proportionate sentencing, and those guide the courts toward restorative and community-based options rather than solely punitive measures. They remind decision makers that justice must be contextual, not colorblind. And so, in short, IRCAs contribute to a justice system that is not only fair in outcome, but also conscious of history, power, and inequity. And so the approach that I take in my work is that I see IRCAs as something that is relational, trauma and violence informed, and grounded in critical race theory and Black feminist thought in terms of my expertise. And so with each report I write, it involves careful multi-step process. And so I conduct interviews with individuals. These are usually 3-hour sessions. And so by the end of it, we establish a really wonderful rapport, but folks are quite exhausted. So in some instances, these sessions could last for 9 hours, three-hour sessions, and so forth, depending on the complexities of the case. And interviews are also conducted with collaterals. And you've heard that term before. Collateral involves family members, friends, community leaders, counselors, anyone that the accused person believes would be an appropriate person to be able to provide a narrative on who they are. And so I explore areas such as their family background, places that they've gone to school, where they've lived, so forth, substance use histories, and so forth. In addition to racism, migration, socioeconomic status, gender, sexuality, and trauma, and how those intersect to impact the person's life. And I emphasize that narrative and making sure that I do that with depth, centering the client's voice and lived experience. And I integrate that into contextual analysis that I've mentioned earlier. So in those reports, we're looking at what are, for example, Black people's presence in Manitoba. What are Black people's experiences across Canada, not just in the criminal justice system, but in general? Like, what do we know about Black people's histories in Manitoba? And I conclude with the person's goals. What are their goals? What are some strengths to inform those goals? And I have some tailored recommendations that support rehabilitation, healing, and connection to community resources. And the aim is to craft a report that is rigorous yet compassionate, a report that honors a person's humanity while also helping the court to understand their circumstances. But, writing these reports are not without its challenges. And so the challenges I face are both systemic as well as practical. And so there continues to be limited awareness and inconsistencies. And some judges or lawyers, for example, remain unfamiliar with IRCAs, believe it or not. And that leads to variability in how reports are received or even valued across jurisdictions. Second, there's systemic resistance, and that remains a barrier. Acknowledging racism and colonialism in sentencing requires institutional reflection and sometimes discomfort, and something that not all systems are ready to embrace. Another barrier is that there's this emotional and ethical challenge that comes along with this work. And so many clients have experienced trauma, violence, systemic exclusion. And so recounting these experiences can be re-traumatizing, especially when time constraints make it difficult to provide adequate emotional support throughout the process. Fourth, there's professional isolation as well. IRCA assessors often work independently without formal peer networks or institutional support while balancing competing responsibilities across practice, research, teaching, as in my case. Fifth, there are pressures from counsel as well. At times, I've had lawyers request revisions that go beyond the assessor's independent role or seek to influence the framing of findings, which raises ethical concerns and requires clear professional boundaries. And finally, funding and accessibility are major issues. Although this is government funded, in some cases, some clients don't qualify for legal aid. And if they don't qualify for legal aid, they'll have to pay for their reports out of pocket. Oftentimes, they cannot afford that. The concern is that with a change in government, will IRCA still be funded? And so, in many provinces, there are no formal funding mechanisms. Like the costs of IRCAs vary across province. And so that means that access often depends on private payment or limited legal aid approval. This results in inequities for those most in need of contextualized sentencing. And so, despite these challenges, we are seeing progress. More judges are acknowledging the importance of IRCAs, and more legal professionals are recognizing them as an essential tool for equity and justice reform.
Thank you so much, Patrina. And I'm glad that you mentioned the sort of barriers with respect to funding, because I would love to get IRCAs for all my clients, but unfortunately, they have to be facing significant jail before we can even get them. But terrific. Thank you. So I'm going to move now to Zilla, our last panelist. And the questions that I had for Zilla, you were a co-writer and an active advisor on the National Black Justice Strategy Steering Group that was prepared for the Federal Department of Justice. Tell us about the pillars of Canada's Black Justice Strategy, the 5 priority areas and overarching recommendations that were advanced in a roadmap for transformative change, Canada's Black Justice Strategy.
Thank you, Wendy, and thank you to everybody involved with the university and the Bar Association for inviting all of us here today for this really excellent conversation. I've really enjoyed listening to my co-panelists and learned a lot from them. I'm going to jump into the Black Justice Strategy. I'm going to see if I can share my screen. I'm not using my normal computer, so we'll see if that works or not. Where are we? I'm not sure what you can see. Can you guys hear me? Or see me? Okay, so I'm not gonna probably share it because I don't know if anyone can see what I'm sharing. Can you?
No, I'm not seeing anything, Zilla.
Okay, I will just go through it then without sharing. Um, so Canada's Black Justice Strategy, as you said, it does have 5 pillars, and I'll just give a little bit of background on the origin of the strategy first. So, it was developed by the previous Liberal government, and in 2021, Prime Minister Ben Trudeau gave the Attorney General, Minister of Justice Lametti at the time, a mandate to develop Canada's Black Justice Strategy. But there was a lot of work and advocacy that had gone into that from Black communities. It came to a head in 2020 with the Black Lives Matter movement, and the killing of George Floyd just south of here in Minneapolis, which sparked a lot of conversation about Black justice. But it didn't start there. In 2015, the United Nations proclaimed the International Decade for People of African Descent. Canada didn't sign on to that till 2018. We have extended it to 2028, but there's a second decade underway now that we have not yet signed on to that goes till 2035. And this was the UN's commitment to improve the conditions of people of African descent worldwide. In 2017, they sent a working group to Canada that stated that it was very deeply concerned about the human rights of African Canadians. Amnesty International has done the same thing. And then, perhaps most critically, there was a very influential report done by the correctional investigator around 2013. And in that report, the correctional investigator found that the over incarceration of Black people in Canada was increasing even faster than the over incarceration of Indigenous people. And it was something that had been completely missed and overlooked by pretty much everyone in the justice system. And this began a lot of conversations about why there was such overrepresentation. And of course, it goes back to the historic situation of colonialism and people in Canada. Without going into, there was so Black people, and very soon after the provinces and systemic discrimination and racism, the justice system. So many people talk about how the justice system took off where slavery ended, and so it was often used as a tool of social control and silencing of resistance within Black communities. And so there has been this negative relationship between Black people and law enforcement and the justice system that is long-standing and goes back centuries and is very unique to Black communities. Other communities don't necessarily have these issues. There are many issues reflected in the Indigenous community. So Black and Indigenous communities have a lot in common on this, but other communities don't necessarily have that experience. So the CBJS launched in 2023, and there's a steering group that advise us. There are 2 authors, myself and Akwasi Owusu-Bempah, who is an academic in criminal justice from Toronto. And we also had community groups in each province who provided us with reports from their communities so that we could get the voices of Black people from across the country. So our 5 pillars, or the 5 areas that we were looking at, were the social determinants of justice, policing, courts and legislation, corrections, and then parole, reentry, and reintegration. So I've heard a little bit about the social determinants today already. So those are basically the factors that bring Black individuals before the criminal justice system, as you might see in an IRCA. For Indigenous people, they would be seen in a Gladue report. And those are things like housing, mental health, physical health, employment, income, and then probably one of the key ones that our communities really highlighted was education. And some of you may have heard the phrase the school to prison pipeline, and that is where Black kids are criminalized and stigmatized from the time that they are very little in school, and they move almost seamlessly from school to the youth criminal justice system. And this is a problem. It's often heard of being an issue in the US. It's also a problem in Canada, and our communities were very concerned about that. Paradoxically, most of the people in our community saw education as their children's best hope of a better future, and they were very committed to a good education for their kids, but they were also very concerned about the systemic racism in education. And that was a big factor in Black youth offending. Policing obviously speaks for itself. So there was obviously a lot of concern about racial profiling, over policing, excessive use of force by police towards Black people. And then the courts and legislation. We tried to take a broad lens with this. So obviously there's the issue of sentencing. IRCAs fell under this. Disparities in sentencing, disparities in who gets charged, all those kind of things. But it also includes justice professionals, Black lawyers, Black judges, a lack of representation, the need for more representation by Black people in all areas of the justice system, the treatment of victims, because Black people are also highly overrepresented in victims of crime, especially murder. And there was a lot of concern in our community that often victims were treated like they were the wrongdoers when they came to court, as well as the experiences of Black people experiencing hate crimes and the lack of legislation to address that. Corrections, obviously, the experience of Black offenders when they are in a federal or provincial correctional institution, and some of the violence that they experience by corrections officers, and some of the lack of cultural supports available to inmates. And then parole, reentry, and reintegration. We found that there's a big systemic issue in Black people being granted parole, that in fact the studies show that Black people are some of the least likely to offend or to reoffend or to breach parole. Like, they have a very high rate of success on parole, but yet have the lowest rates of parole being granted. So there's a huge discrepancy there that needs to be addressed. We had several guiding principles of our CBJS, and I think that these are also principles that apply to access to justice, because I think when we talk about access to justice, it's very broad. So it's not just about, having a lawyer paid for and coming to court and having a hearing. There are so many other issues that come up. So really what access to justice is having a fair, an unbiased, and representative justice system that looks like the people it serves and represents everybody and doesn't have discrimination embedded in it. So our guiding principles were Sankofa, which is a West African concept, a Ghanaian concept of looking backwards while moving forward, so that you're bringing your traditions and your legacies, but you are moving forward and looking to the future. Afrocentrism, so Black people were front and center and the most important part of this principle, of this strategy. And so that's why the community voices were so important. The principle of restraint, so that goes to sentencing, where to other things as well, but primarily in sentencing, that you do the least restrictive thing that you need to do to accomplish what you want to accomplish. So if a 1 month sentence will do it, you don't give the person 6 months. Evidence-based decision making, that's a huge one, and it's a big issue right now with the whole conversation on bail reform. So get the data, get the statistics, and then make decisions that follow through on that make logical sense. And what we found was that we are lacking a lot of data on Black people in justice system in Canada. So a lot of our recommendations had to do with gathering that data. Reparative justice, sentencing circles would be an example of that. Justice that actually mends harm and brings communities together and lets people reflect on what they did wrong and take accountability. And then we acknowledge that Indigenous and Black liberations are intertwined, as I sort of discussed already. We had 5 priority areas: decarceration, legislative change, because we wanted mandatory minimums to be lessened and other things as well. The immigration deportation laws to be changed, targeted resourcing, structural change, and collaboration with provinces, territories, and municipalities. So one thing I will say, just to finish up, is that the strategy is not done. So while we did write the strategy, we also have an implementation group, which has many of the same people from the steering group. And we are continuing to advise the Minister of Justice. We just had a meeting with justice officials last week, and we are meeting in Ottawa with the minister in a couple of weeks. Sean Fraser is now our minister. And we are continuing to press the government. They did respond to our strategy with an implementation plan, and all these documents are available on the Justice Canada website under Canada's Black Justice Strategy. So they came back with an implementation plan where they committed to several things, one being funding for IRCAs, which we just heard about from Dr. Duhaney, that's needed, and they committed to that for 10 years, and to other supports for Black businesses and other measures that they took. But then we see things happening like the new crime bills and the whole issues with bail reform and some of the measures that have been suggested that go against everything we talked about. They go against the social determinants of justice. They go against rehabilitative justice. They go against evidence-based decision making because these bail reform principles are not based on evidence. And it's kind of disappointing to us as the steering group because when we talk about access to justice, one of the primary things is that we as a Black community be heard in the justice system. And we had written so much in our strategy about the history, about how we got here, about all the reports, about all the findings that had been made about systemic racism. And we thought the government had heard that. And yet it doesn't seem that they have. So the fight continues. When you look at all these things like IRCAs, really what underlies it all is that Black people in Canada are not seen as unimportant people, not seen as facing systemic racism, and not seen as really having grounds to bring these issues forward. And so our mission remains to improve access to justice by having our community heard. And so those are my points on that. Thank you very much.
Terrific. I mean, this has just been such a fabulous panel. What I'm going to try to do, because I had a question for each of our panelists to sort of wrap up before we moved into the questions. But I think what I'm going to ask them to do, because I'm going to try, there's so many good questions here. And what I'm going to try to do is have our panelists answer that question with the question I'm going to assign to them from our Q&A. And if I'm really going to try to synthesize some of the questions so that all of you get your answers. So I think I'm going to start with Judge Ryle first. And Judge Ryle, the question I'm going to give you from our group here is, it's the first one, and it says, from what I've read on the topic, while Gladue Reports considerations have been around for a long time now, we've not seen significant movement in the overrepresentation of Indigenous peoples within the justice and carceral systems. One of the main reasons what I have seen anecdotally for this seems to be that the presence of violent crime will often effectively remove the availability of non-custodial options, despite violent crime often emerging from the same harms as non-violent crime in terms of trauma, colonialism, and the other barriers often faced by Indigenous peoples. And so that's a big one, but I'm going to give it to you. And then if you could also maybe answer, and because this was a question I put to the panel, what would access to justice look like to you in 10 years if you had your way, basically? So if you can add that into your comments and try and keep it to about 3 minutes, we'll be on target. So I'm asking the impossible, but there we go.
Sure, thank you for that. And just in terms of the comment that was made, or the comment question that you read in, certainly, sentencing does need to be proportionate, and there is case law that indicates that if there's more violence and more harm, that taking into account everything, that often a jail sentence is still required. And I'm just looking at the comment again. I see that it seemed to have disappeared. It moved to answer. Thank you so much. So I'll leave it at that, as it's more of a comment. But in terms of looking to 2035 in 10 years, it would be nice to see restorative justice practices being the norm. And I did see one of the questions in the chat there, that I do think that the restorative justice principles, including circles, can be used for everyone, not just Indigenous peoples, not just other systemically marginalized groups. And that is something that I would like to see in 10 years, as I do think that it promotes a system that is more healing, and the healing doesn't compromise public safety or accountability at the end of the day. So that's my vision for 2035.
Yeah. And maybe that will be an aid to reducing the over incarceration, because I think that's the frustration that we all feel is, how is it that we're doing the best we can to implement and address over incarceration, and yet why isn't it working? Which is why I think it's a perfect segue to MKO, because I really do think it comes from the community. And I think a lot of these questions that I'm going to sort of synthesize for you, Melissa, is that the questions here, could you please provide more information about the wellness and healing plan? Specifically, how would it be operationalized? For example, would a defense lawyer refer an individual to counseling services, and would the outcomes of those sessions then be incorporated into the Gladue report? Additionally, would these services be offered through MKO or through an external counseling organization? Would the counseling services be offered only within Manitoba? And if so, how could this initiative be expanded to other jurisdictions? So it's a real whammy, but I think it does get at a lot. And I'm going to ask you to also answer Cynthia Murdoch's, through a traditional lens, what cultural approach when developing sentencing circles. And I would ask if you could consider, like, far northern communities are often, and oftentimes it is an impact of colonization, but very Christian centered, where there's a resistance to healing circles or sentencing circles. And maybe if you could also address that challenge that sometimes is within the communities.
Yeah, for sure. Thank you. Okay, so the first question in terms of the MKO Gladue Wellness Initiative, I do not have all the details yet. As I said, we are still in discussions internally, but also have had discussions externally with our partners. So in terms of, first and foremost, this initiative would be solely offered to MKO communities and members of MKO. Not to say that, you know, we have a lot of, we share as Indigenous people, we share our knowledge. And so, you know, when someone comes and wants to have some bannock and tea and have a discussion, we are definitely open to having those discussions with our other relatives and various other organizations. So I don't have a definite answer for if we're going to be referring an individual or the process yet to date. However, once we get the approval, once everything's finalized, there will definitely be more information to come in response to our initiative with respects to the Gladue Wellness Project. Sorry, I don't have more answers than that at this time. Through a traditional lens. So yes, first and foremost, as I mentioned, what the question was, what cultural approach when developing a sentencing circle? For myself, generally, as I mentioned, as Anishinaabe Kwe, I've come to find the balance between walking the red road and also walking the present road. So that means being able to, for personal and professional, I've been able to bring both worlds together. So again, you know, my worldview is the circle, and in modern day and present world, a lot of it is built on hierarchy. So that triangle fits within our circle. So when I'm conducting those circles, I am able to, depending, again, also this will answer the other question, depending on the community or the individuals who's part of the circle. The first and foremost thing is really important, because I've been in situations where the judicial has requested this, but before we can decide even what type of circle it's going to be, we have to have those conversations with the people involved, right? And this allows me to find out who the individual is, what path they walk, and at that point, then that will kind of have a ripple effect into what type of circle. Also, what I do when we're conducting circles in First Nation communities is on reaching out to leadership, finding what they would be welcoming, as well, in terms of a traditionally led circle or a non-traditional led circle. But first and foremost, again, offering my tobacco. I know a lot of people don't understand the importance of that, but it's the first thing we do. So I'm offering that tobacco, and again, that tobacco is already going to act as the conduit to the guys that I'm going to ask to help me and assist me along that path. And then from there, talking to the individuals, and then it's just going to have the ripple effect. Are we going to go into a traditional? And so a traditional for me is incorporating ceremony. So when I'm talking ceremony, I'm talking about probably bringing in somebody to do a pipe ceremony. Smudging it is still ceremonial, but it has grown to so much more than that. It's almost comes as a checklist to ensure. But again, depending where you go, you always need to consult with individuals. And for the remainder of time, it is going to be a challenge in some communities that still are heavily based, and will be for maybe the rest of time. They'll be heavily based in Christian or Catholic beliefs, and that's fine. But again, we have to be respectful to whose territory on and the protocols that they follow as well. But I've come across some people who are really rooted in those values, but as we continue to evolve and really listen to the needs of the individual and the wants of that individual, leadership tends to open up a little bit more and be more accepting of what the individual needs. Not in every case, but I'm saying it's becoming more. There's more listening happening. And then so first and foremost, tobacco, consultation, talking to the individual. And then from there, that is just going to lay, and I always find that it just perfectly comes out. There sometimes are some bumps, but the circle itself will happen. So I don't have no formal process to do things, because again, for myself, as an Anishinaabe Kwe, it's in my DNA. I kind of know what to do, but I also respectful in terms of for people who it may not be. And so yeah, so there's a little, I've created a little document what the protocols would be. And some people will affect the four circles of the medicine wheel. For some, they might be based on the 7 sacred teachings. For Anishinaabe people, it might be based on the 7 sacred Anishinaabe teachings. Again, it's going to vary each to community. Was there another question, or did I answer?
There's one that just came in. I think maybe between you and Judge Martin, there's one here. It says, in cases of interpersonal violence, how is re-victimization avoided in a sentencing circle? For instance, the trauma of sharing space with someone who's participated in abuse. I mean, that is just a fabulous question, because I think those are the ones that pose the most difficulty for whether or not a sentencing circle will even happen in the first place. And so maybe Judge Martin, if you could, and then Melissa, if you have thoughts on that, that would be terrific.
It's a very interesting question, because it's one of the ones, and as well with respect to sexual offending, whether it's against an adult or a child, is always kind of been in the back of my mind as well. How do you do that? But we have to remember back to Hollow Water. Hollow Water had, and I can't remember what year it was in, if it was in the 70s or the 80s, a very, very successful program with healing circles for sexual offending because they were having some issues in the community. And I'm told, of course, I wasn't part of that, but that it was very successful. How you navigate that, I would have to leave that to somebody like Melissa Brown about getting people ready, open to the process, making sure that there are not any imbalances. And as Melissa said, it's a circle where everybody has a responsibility where there are not supposed to be any power imbalances. So how that is actually achieved, I think that goes back to people like Melissa who facilitate and actually have these programs running. So I'd actually like to hear from Melissa because I saw her nodding her head when I said hollow water, but if she has any recollection or knowledge of that, I'd love to hear from her myself.
Couldn't unmute myself. Yeah, no, hollow water. I remember it, and I was like, whoa, this is happening. And it was such a stepping stone, I think, in the right direction, especially when it comes to IPV and sexual related offenses and whatnot. Because again, it's really, really important when we need to bring healing and I'm going to speak really broad here. As Canadians, we all have a responsibility to ensure safety, in communities, in our homes. And I think that again, that was the stepping stone, how there is going to be the shift in how we are conducting our courts, how we're conducting our administration of justice. And again, I can only speak specifically to First Nations people at this time. But no, hollow water was a huge stepping stone. And I do believe, again, you have to factor in everyone. You have to speak to everyone. We can get a recommendation. Doesn't mean we can just go in and get it done. It's all about speaking with everyone, ensuring that they're okay with this, and ultimately bringing that healing and that balancing post circle. But again, where work still needs to continue to be done is really post circle to ensure we're bringing in the appropriate resources and support post circle. But yeah, I would
Well, and
I would like to see more of it as
yeah,
well happen. And just again, we have to ensure that everything's in place, everything is set up to ensure the safety and well-being as we journey towards that healing and safety for all.
it's an interesting community because it really came from the community. I think they were seeing successful prosecutions because victims didn't want to come, and the offending was continuing. And so they came up with a solution that was accountability without the fear of necessarily going to jail, but to change the community and look at how what the history of why this was happening within their community and change the people that were offending so that the victims could be safe. And so I think we could go back to that as a model. And certainly I'm doing so many of these cases up north now that I'd sure like to see something different because I don't think it's a win-win for anybody up there. But that's for another day, maybe another session. I might, though, there's some questions here on IRCAs, and so that brings us to our next two panelists. And there's one that asked about the who could get, and so this might be for Patrina, available to all those who have been impacted. Are IRCAs available to all those who've been impacted by race and culture factors like all immigrants, or is it specifically available for Black people as an overrepresented group in the justice system? And if you don't mind, maybe you could throw in question 2 from Paulo, since IRCA reports are relatively new, what key metrics or qualitative data points should the legal community monitor to evaluate their long-term effectiveness in addressing systemic racism for non-Indigenous racialized individuals? What does success look like in this context? And Zilla, when I come to you, consider his number one, and then the other question that's coming about from Lindsay LeBlanc about the bill C-14. I think you had sort of talked about that a little bit already, sort of the weaponization, frankly, or politicization of the justice system, which is a problem for not just, you know, well, anybody involved in the system. It just feels like politically everything we're trying to do is weaponized and politicized, and it's just so difficult to keep the conversation about moving forward in a way where we're trying to keep communities safe and stop reoffending in an effective way, sort of evidence-based, right? Yeah. Okay, so I had my 2 cents. Your turn, Patrina.
All right. Yeah. I mean, really great question here. So I'll just give you some context in terms of IRCA. So other jurisdictions across Canada, such as Ontario, they're using terms such as Morris Report and Enhanced Pre-Sentence Report. But the term Impact of Race and Culture Assessment, or IRCA, that was first developed by Robert Wright, a social worker and therapist in Nova Scotia. And that was intended to respond to the overrepresentation of Black people in the criminal justice system and help courts understand how anti-Black racism and systemic inequities shape their pathways into the criminal justice system. And so although IRCA's originated to address anti-Black racism, once the government got wind of it, they wanted to consider other racialized populations as well. And so definitely IRCAs can be used for various racialized populations. I have written IRCAs for racialized groups, but a caveat is one of the things that we need to take into account is the history. And so what I mean by that is history matters. IRCA, the framework was born out of the recognition of the historical legacies of slavery, colonization, segregation, and systemic racism in Canada. And so those forces produce racial disparities in education, employment, police, and incarceration. So if we look at statistics, the two groups that are most overrepresented in the criminal justice system are Indigenous and Black individuals. And so one of the challenges I find as an assessor completing IRCAs for other individuals who are racialized, without that historical context, it's really hard. It makes it difficult to sell, the deep histories, if that's not existent, it's very challenging to really provide that context. Again, another challenge is because we have only recently started with this aggregated race-based data collection, we don't always have concrete evidence of people's lived experiences in the criminal justice system because our government has grouped everyone together as visible minorities, which is problematic. I know that's changing, but we still have a far way to go there. So that makes it really difficult for other racialized groups, especially if they're not necessarily as overrepresented in the criminal justice system as Black and Indigenous individuals. So really have that data to substantiate that historical background.
I want to thank our panelists. What an absolutely wonderful treat it was to have you all come together. And I'm sure all of you are feeling like I am, that there's just so many connections and layers here and food for thought for another day. But thank you so much to all of you for dedicating your time and energy and thoughtfulness to making access to justice a real part of our daily lives. I think there's so many things happening within our society across the border that make us all feel very nervous. And I think the more we do this, the more we connect, the more we are out there educating each other, learning from each other, the more we're going to find the solutions that aren't going to be grounded in fear. And so I'm so appreciative of all of you for contributing to that process. Thank you very, very much. And thank you to all of our participants that joined us today.